In the matter of the Managing Director versus PEDDI Narayana Swami, the Supreme Court upheld the decision of National Consumer Dispute Redressal Commission. However, it said that amount of compensation with regard to liability of appellant or the hospital would stand at 10 lakh rupees along with accrued interest. Appellant, which was the hospital, was being held vicariously liable for medical negligence and foisted with a liability of 15 lakh rupees with further compensation of 5 lakhs upon doctor of hospital totaling 20 lakhs by National Consumer Dispute Redressal Commission, New Delhi. By order of 26 August 2022, it has challenged the said order with the order dated 8 March 2011 of Andhra Pradesh State Consumer Dispute Redressal Commission. The challenge was on the ground that liability as has been imposed on appellant and proforma respondent number 2 Dr. J.V.S. Vidyasagar on ground of negligence without there being any medical literature or evidence of experts substantiating the said findings deserve to be set aside. Having considered submissions made by counsel for parties and upon going through records of case, Supreme Court said that it is apparent that there is ample evidences as well as records to indicate that there was medical negligence at end of applicant and respondent number 2. Findings thus returned by the APSCDRC and NCDRC in this regard cannot be invalidated and are affirmed. The son of complainant was 27 years of age at time of his death, which is prime age when a person starts his career and his whole life to look forward to. Considering that individual was a BTech graduate and was working in a soap factory, albeit drawing a modest salary in beginning when youngsters start their career generally, humble short steps are taken. It is evident that he was financially supporting family and had qualification potentiality for higher income in future. Therefore, it cannot be said that compensation has been assessed by NCDRCs without any basis or quantum is on extremely higher side. As matter of fact, NCDRC has fixed compensation 5 lakh rupees to be paid by Dr. J.V.S. Vidyasagar, pro forma respondent who has accepted the said judgment and has even deposited said amount. As regard amount of rupees 15 lakhs is concerned, which is assessed to be paid as compensation by appellant, it would not be out of way to mention here that while issuing notice in present case, court had directed appellant to deposit amount of 10 lakh rupees in registry of the court to be invested in short-term fixed deposit to be renewed from time to time. Court said that we have been informed that said amount has increased with auto renewal facility over period of time and we are thus of view that amount of 10 lakh as stand deposited by court by appellant along with accrued interest would serve interest of justice and said amount of compensation would suffice as far as liability of appellant hospital is concerned.